many of these things and other agencies. And so even though we're looking at new legislation, we also are here to hear you out so that, in fact, we can begin pushing on the executive branch to assert powers they have, which, for example, somebody selling gummies and implying that. The fact is it's a deceptive practice, and hopefully in the days and weeks to come, we will see enforcement that might save you the "I'm tired of whack-a-mole," even though it was important for you to do. With that, we go to the gentleman from Texas, Mr. Moran.
Thank you, Mr. Rice. Ms. Wilson, I see you have your hand up, so I'm just going to ask you why you have your hand up.
Because they tapped me on the back and they said it's time for me to go to Music Care's rehearsal right across the street. And I just want to say thank y'all so much for y'all's time, and this is awesome to be a part of. Thank you so much. I'm going to go to rehearsal.
Thank you.
Thank you.
Thank you, Mr. Chairman, and thank you to each one of the witnesses for your time and your testimony here today. I know it's very valuable. Proudly, I am one of the 5 original sponsors of the No AI Fraud Act, along with Ms. Dean. And I'm hopeful that exposure from this hearing in particular will help move this bill through committee. But I also recognize that these kind of hearings are very important to hear constructive feedback, to hear criticisms, to hear pushback, because we should never enter into new federal legislation lightly. In my opinion, I think we need to take it in a prudent fashion, and we need to consider all of the voices that are here today, and we need to fine-tune what we're trying to propose so that ultimately, if we pass something, which I hope we do, it will be beneficial to all, and it will be the appropriate language. We don't want anything under-inclusive. We certainly don't want anything overly broad at all. So with that, I specifically want to ask Ms. Rothman a bunch of questions today, because you've provided a lot of pushback, but Ms. Rothman, a lot of it's been very thoughtful, and I appreciate that. Let me just make sure we start from the same foundation on a few things. First, do you agree that individuals should have a property right in their voice and likeness?
Well, the property, I'm supportive of it being a property right as long as it's not transferable away. And sometimes people think of property as being sort of a simplistic thing that is automatically transferable, and it need not be. And that is another reason why I gave some examples of things we don't allow you to transfer, even if we understand them to be property. So I think it's appropriate to understand people as being able to own themselves. You can style it as a property right. Some states style state publicity laws as purely personal and say it's not property. There is a conflict in the law about that terminology, which is why I paused. If you're asking my personal opinion, I'm fine with it being classified as property as long as it's not transferable away.
Right. I know transferability is your big issue, but there are differences in state law. State to state deals with this right to publicity a little bit differently. So do you agree that there's room at the federal level for us to try to bring harmony to this issue?
Yes, I do think it is an opportunity. It's a very challenging task just because of the length of time these publicity laws have existed, and to the extent that they originated right in the late 1800s, early 1900s as part of the right of privacy that became the privacy rights that we more broadly understand, including constitutional privacy rights. Those are actually the same across all the states.
And I'm going to have to just stop you because I got a lot to ask. So hold on. You mentioned in your testimony, your written testimony, you said absent jurisdictional hurdles, Tom Hanks, Drake, The Weeknd, each have straightforward lawsuits under state rights of publicity. So give us examples of those jurisdictional hurdles that you're referring to there.
Oh, so in the footnote in my written statement, I go into it. The only major jurisdictional hurdle is my understanding that Drake is Canadian, and so some state laws limit rights to those who are domiciled in the state, and since he's not a member of any state,
right? So we have some international issues. We have jurisdictional issues. We have state-to-state differences on how it can be enforced. In certain circumstances, an artist would have to go state by state by state effectively to enforce their rights. Isn't that true?
So Drake would likely have a federal claim already for trademark violation and unfair competition, plus, as Chairman Issa mentioned, the FTC.
In other instances, they would have to go state by state by state, and they would have different remedies. They'd have to go to different courts. They'd have different venues that they would have to pursue to have their rights protected. Correct?
I don't think that's true. That's not how litigation currently works. Even Ms. Wilson departed, but she may need new legal counsel. There's a lot of lawsuits she could be bringing and that she would be winning, right? We read all the time about celebrities whose images and names are used for false endorsement. We could go back again to the early 1900s. These are winning cases. People win them. They can publicize that they win them, and they're big penalties. And you can, if you win in California, you get your damages. You don't have to then litigate in all the other states.
Yeah, but you also mentioned in your written testimony that the case law does not provide a stable or predictable roadmap for Congress to employ at the federal level. If it's not a stable or predictable roadmap for us at this point, state by state, then we need to create some kind of federal roadmap, in my opinion, to protect folks. Do you agree with the concept that artists have the right to all three, credit, consent, and compensation when their voice and their likeness is used in for commercial purposes or otherwise?
Yeah, so the quote, I think, was taken with regard to copyright preemption specifically rather than the prima facie laws. But I think you said that very quickly about credit, compensation, and consent before someone's name, voice, and likeness or performances are used. Absolutely, people should be consenting for those. Whether they want compensation or not may depend on context. And credit, as people in this room probably know, is something that is sometimes negotiated with a lot of vigor, particularly in movie and TV credits.
I know I'm out of time. Some of my time, by the way, was taken for the exit, but I will say that I have not mentioned Travis Kelce's girlfriend once during this testimony. But I want to encourage this. I want to encourage the continued dialogue, and if there are additional things that we need to look at to sharpen up the No AI Frauds Act, happy to do that. But I think that it's incredibly important for us to protect human creativity, both for the individual and moving forward. I do agree with Mr. Gates and a number of the other people on the panel that have said, look, there is a liberty in the right to contract out that, and if we need to somehow make sure that protects their personhood going forward, we can find a way to shape that. But we certainly have the right to say, hey, it's my name and likeness. Why can't I contract out or assign out the rights to that so that I can make money now or my family can make money in the future? Would like to work with you on that. Would yield back my time. Thank you.
What time? We now go to the gentlelady from Missouri, Ms. Bush.
Thank you, Mr. Chairman, and thank you, Ranking Member, for holding this hearing. And thank you to all of our witnesses for being